Hi there, I'm Mike Wheeler, the editor of Inside Waste magazine, and welcome to the Inside Waste Management Review podcast. Our first guest is Gavin Shapiro, who is an environmental lawyer for Hones Lawyers. He's also a partner at the firm and specialises in helping the waste and resource recovery industry.
G'day, Mike.
Yeah, welcome.
Thank you. Glad to be here. Honoured, I should say.
Well, you're our first guest on the podcast, so really glad to have you here. Look, I thought we'd get stuck straight in. You wrote a recent column for Inside Waste, which will be appearing in the next issue, about director responsibilities when it comes to the waste industry. I'm just wondering, what are some of the common misconceptions, or what are the instances you've come across where a director has either purposely or not purposely not met their obligations, and what are some of the repercussions of that?
Sure. Okay. Starting with a misconception, as far as the legislation's concerned, if your title's not a director, you can still be prosecuted under the same legislation. So anyone in a management position, and sometimes companies may have corporate structures where there's multiple companies, multiple entities. So multiple managers might be able to be pinged, and a lot of people don't realise that. So that's one misconception I've seen a bit, where people think because their title is, they're not officially a director or not officially a manager, but it's really about the responsibility and duties you have. As to the mistakes or what's not done, I'll reverse it a bit. The only defences to some of those provisions are due diligence defences, where essentially you've done everything possible to prevent the commission of that offence by the company. Now, what does that mean? In practice, it means you have to have incredibly strong systems and procedures in place, environment and health managers, people in those positions, depending on the size of the company, written procedures that you can point to and show the EPA or a court if need be that you have those in place, regular training, toolbox talks, audits, all that sort of stuff really is the only way you might be able to successfully argue your way out of that. So if something happens on a site, and I've seen it where it's a pure accident, maybe where a contractor, a third party, is the one who actually caused the spill, leak, offence, whatever it is. But if you can't point to all those systems, procedures, and due diligence in place, then really, as a director, you're at the mercy of the EPA as to whether they think they should go after you personally or not.
So ignorance is an excuse, and
there's unfortunately, well, I say unfortunately for those in the waste management industry, the way environmental legislation works generally across Australia is strict liability, which means you don't have to have that mental element. There doesn't need to be any element of fault for most offences, other than those about misleading information and stuff like that, because the broader public policy goal is to protect the environment, to protect consumers, to protect the public. So that's why a lot of the normal things you think of with criminal law about mental element or intending harm or what have you don't necessarily apply.
So what you're saying is that when it comes to third party thing, I just want to clarify that a bit. If you've put all your procedures in place and you've followed them all, and you hire a third party to do something for you, and they caused an incident, are you still liable? Or
potentially, yeah. So
even though you put everything in place?
I've had two cases where the EPA has prosecuted a client of mine. Now, they didn't prosecute directors in that case, and I think that's because the company did have very good procedures in place, the two companies. They did prosecute the company, though, because the company held the license. And for some offences, it's the license holder or the landowner or occupier who might be liable. So that's who the EPA went after in those cases, even though in one instance, a third party literally came on site, a contractor came on site to proactively fix equipment. In doing so, they disobeyed the procedures that they'd signed that morning, Friday afternoon, 3:30. They obviously wanted to nick off to the pub, and they skipped some of the procedures. This was actually ammonia cooling equipment. Skipped some of the testing procedures, just reconnected, and boom, ammonia came out. And the client rather than the contractor was prosecuted for that. So to answer your question, yeah, even if you've got procedures, everything in place, the company can still be prosecuted, but it does potentially protect the directors.
Actually, just going off on another bit of a tangent, one thing in your column I also found interesting was you gave an example of a general manager of a council being prosecuted. You said that and I just will read out here, we're talking probably the New South Wales EPA here and
Yeah.
them because you're based in Sydney, but so it could be different in other states and territories. But they went after the council, which you said was they used to go after the small guys, but now they're starting to go after the bigger guys.
Yeah.
The council, if you're a GM of a council, that would be quite worrying. Possibly.
Big. Yeah. That's exactly right. So it is, a lot of this is common across Australia. There's small differences in the legislation and case law, but the jurisdictions all generally copy each other, and the small jurisdictions often copy the bigger ones. As technology develops, as different practices develop, environmental legislation develops a lot quicker than a lot of other legislation because of that public protection, public policy aspect. So there is a lot of commonality. And as to the council thing, yeah, that was quite interesting. It was, I think you could say, until about 5-10 years ago, the EPA had only gone after directors under these director liabilities of companies with 1, 2, 3 employees, where it was really a one-man band sort of thing, a company in name only sort of operation. But I've been involved in a number of investigations where you're talking companies of 5, 10, 20 employees. And this council one, it was a regional council, so smaller than your Sydney Metro type one, but that's possibly the biggest, certainly one of the biggest organisations where the EPA has gone after the director. And that went on appeal. That went to the Court of Criminal Appeal because it was a really tricky question as to whether the general manager of a council, which is not a corporation in the normal sense, it's got corporate personhood under the Local Government Act, but so it was a technical question as to whether or not it fell under the legislation, and the fact that it did, and more importantly, the fact that the EPA was willing to go after a council GM shows that it's really broadening its sights to bigger organisations. And as I said, I've been involved in investigations where the EPA has turned its attention on directors, or not really directors, but managers of larger organisations. Fortunately, in that case, we were able to convince the EPA not to ultimately prosecute. And I think it, justified in those circumstances. My clients are always innocent, but it's definitely a worrying trend at those sort of middle-sized companies.
Just briefly, can you touch on what the case involved, and was it upheld under appeal? Or?
Yeah, so what it involved, I can't recall precisely. There was a pollution incident of some kind. I can't recall the precise details off the top of my head, but essentially the council was prosecuted, but the EPA also sought to prosecute the general manager, but the court at first instance held a GM was not a director or manager of a company, and therefore executive liability didn't apply. The EPA appealed that and was successful, and on appeal the court said a GM is liable under executive liability.
Oh, well, interesting.
Yeah.
Let's dig a little bit deeper into the EPA. They used to have quite an adversarial role. They've got when I say a new CEO, it's been in the job for about 2 or 3 years, seems a bit more collaborative with the industry than perhaps previous regimes. How have you found dealing with them?
I think it varies. What I've found is it varies from branch to branch and varies from then company and licensee to different companies and licensees. What I mean is, some EPA branches are almost little fiefdoms in regional areas, or, the waste branch has almost always been more adversarial than some of the other branches within the EPA, contaminated land, etc. So some of those sort of mid-level managerial roles, people put their own spin on it. We've had some famous EPA officers, compliance officers in the waste branch in the past who I won't name on the podcast, but who've been very adversarial. So there is some ability internally for those officers to also take a slightly different attitude than might be the message coming from the top. And also the truth is we're all human. EPA officers are also human. Some of the listeners might be surprised to hear, but they are. And so what I've also found is if particular officers, particular branches form a bad view of a company, of a licensee, then the relationship becomes adversarial. Whereas, so to give one example, a larger client, licensee with multiple operations, multiple licenses, we went through a period of a few prosecutions and quite a few incidents, and the relationship was very adversarial at the time. But that client then invested a lot in personnel internally. They created additional risk management roles, additional, they already had environmental roles, but additional roles, internal audits, as well as investing in regular meetings with the EPA, regular liaisons, so that now we've found when issues come up, there's a lot more trust. And so the relationship really is a lot more collaborative and understanding. Whereas I have other clients where that relationship is, there's very little trust. So as soon as something happens, naturally as people, some of those EPA officers having a dim view already may assume the worst, may assume that they're already, sort of criminals and start from that as a starting point, which leads to a very adversarial investigation. Whereas others that have worked well with the EPA, you find the investigation follows a very different path. So probably there has been some different direction. I've found some collaboration, particularly in the metro region, but it really varies branch to branch, officer to officer, and company to company.
One thing you sort of finished off your article with, or you sort of, this is the recent article you put in the magazine, and just bringing my EPA hat on here a little bit, they're just the enforcement agency, right? So it's really up to you to follow the rules. Is that the way you look at it?
Well, yes. Yes is the short answer. They are the enforcement agency. What's somewhat tricky about the EPA in some of the states and territories, including New South Wales, is they have two hats. They're your licensee, so they're the regulatory agency that you're coming to when you want amendments to your license, increased capacity, but they're also the enforcement agency, and peculiarly, in some instances, you'll have the same EPA officer or same group in the waste branch, for example, assessing your license applications as doing the enforcement, which I'm not personally a fan of, because I think, the once someone has a dim view from an enforcement perspective, they're naturally going to apply that to their regulatory role as far as licensing is concerned. But as to the second part of what you said, yes, it's up to you to follow the rules, although, and to put those systems and procedures in place, although in practice there are times where unforeseen events happen, and all you can do is really put in place the best systems, procedures, proactive measures, maintenance, and all the rest as you can to prevent that occurring, limit that occurring, and if something does occur, then to have a reasonable explanation for that, so that you can convince the regulator that, this is a one-off. You don't need to go after us because we've got fantastic systems, procedures, all the rest. We're a good corporate citizen. And in often, cases that's the case. The EPA lets you off with a warning if they do believe that it's a sort of genuine one-off where you're not really culpable for something having occurred. With that said, in waste particularly, there's a lot to be aware of as far as the laws, resource recovery orders and exemptions, testing, a lot of obligations that apply. And so when it comes to something that's not really an incident, not a pollution incident or a mishap, but effectively just not complying with those requirements, they're often less understanding.
Yeah, it does seem to be from the outside looking. I've been in the industry 4 years, and so I've seen a lot of EPA fines and like some are quite substantial too. But it's a bit of a just talking to people in the industry. It's a bit of a nightmare, this licensing, in terms of what they're allowed to do, what they're not allowed to do, and there's exemptions here. There's again, I was looking at a case you did a while ago. I don't know if you remember Crush and Haul, where they where they did they had 30,000 tonnes and they went above. It's just like the people are really, most people, except for dumpers, are doing it with good intentions. You know what I mean? Like most people in the industry I know definitely are trying to.
I agree. I mean, to give you the most frequent example is asbestos. If you're dealing with construction demolition waste, if you're dealing with a MRF, it is almost impossible to prevent some level of asbestos contamination, no matter what systems and procedures you have in place. At some point, somewhere in a skip bin, something is going to be placed, not by the waste management company, but by at the demolition site, wherever it is, that may cause cross contamination. And then there is an issue of interpretation when you look at resource recovery orders and exemptions, when you look at your license, as to whether or not that there's a zero tolerance, whether or not there's some allowance for some cross-contamination. And the EPA, for example, has firmly been of the view always that there's a zero tolerance. There was a series of cases, the EPA and Graffel and Mackenzie, where the number of recyclers had sent material under resource recovery orders and exemptions to a site. Graffel and Mr. Mackenzie received that material. I believe they received certification stating it complied. As it turned out, some of that material was asbestos contaminated. EPA prosecuted, court at first instance found they were not guilty on the basis that their obligation under the order was just to receive them. That they really had no obligations. It was all on the recycler. And on the basis that the asbestos level was fairly low, 0.00 something percent, that was overturned on appeal, where the court effectively found 0.00001% asbestos means it doesn't comply. And that case went backwards and forwards on appeal a few times as far as then sentence and all the rest. But that showed that even within the judges of the Land Environment Court and Court of Appeal, there were differences in interpretation as to how some of these rules and regulations work. There were differences in interpreting whether there's a threshold, is it zero tolerance, on the same document, on the same wording. So how is a layman, when eminent judges have differences of opinion how you interpret this stuff, how on earth are people in the industry supposed to interpret this stuff? So I agree completely, Mike. Trying to deal with the enormous amount of regulation, documentation that you have to deal with is incredibly tricky. And, I said before about having systems, procedures, all the rest. But the truth of it is you end up then with these long systems and procedures. And, do we really expect a forklift driver or a guy in a truck to have memorized all these documents? So it is really tricky, and most people are there with the best of intentions.
Haven't they? I could be wrong here. Haven't they re-looking at just asbestos? I know we're on that subject about they are going to make it a little bit better than just 0.001.
I believe that's yes. So there is a the EPA did come out, I think, with a draft policy relating to, I think it was, can't recall off the top of my head whether it was C&D waste or something, but it was essentially for testing, and there was an allowance, I think, in accordance with Australian standard. for some level. Essentially, if it was below the detection level, then it was okay. I say okay. That's not enshrined in law, I don't believe, but that there has been some looking at that. With that said, I should add, because of that, the asbestos in mulch, that
Roselle, yeah.
basically the biggest investigation, I think, or one of that the EPA has ever carried out. The laws were tightened a lot in regard to asbestos. There've been a few rounds of amendments, but there've been specific offences introduced in relation to asbestos in waste and asbestos. There've been offences introduced for breaching resource recovery orders and exemptions, and some other changes and increased penalties in relation to asbestos, and all the rest. So yes, there is some looking at that, but at managing asbestos, but it's a tricky topic, and nevertheless, what's out there on the law books at the moment is still pretty frightening.
At least you can generally see asbestos. PFAS you can't see.
Yes, that's true.
Do you want to talk about PFAS?
I mean, PFAS has been a big issue in the contaminated land side of things. Less so in the waste side of things, but yeah, just because of the nature of PFAS, particularly being in ground and surface water, I suppose, whereas waste is typically on the surface. But the PFAS is a big issue, hot topic at the moment.
Yeah, it's very hot. Last question before we wrap it up. Just if Gavin ruled the world, what are a couple of things you'd like to see if you to make life easier, maybe for the EPA, maybe for people within the waste industry? Is there anything you experience you think could help?
Number one, while I think of other things, number one, without a doubt, is the way waste is defined in most states and territories, and particularly the way it's been defined and applied by the courts in New South Wales. In theory, second-hand clothes, second-hand cars, all sorts of things would be defined as waste because the person who they came from, the generator, no longer has a use for them. They're surplus to them. That automatically makes it waste. And when a house is being demolished, even though someone may be specifically separating the material to recycle bricks or wood or whatever it is, that is waste, and so on. And there is no provision for it to become not waste, and there's no clear guidance on when it ceases being waste, and that's deliberate and deliberately ambiguous because I think the EPA takes a view that the wrongdoers, the guys who are deliberately falsifying dockets or doing what have you, would drive a truck through any loopholes and try to argue that the material's not waste and get away with it. But we talk so much about a circular economy and all the rest, but having that ambiguity about if it goes through a MRF, is it still waste? Probably, arguably. If it goes through beneficiation or some other process, when does it stop being waste? And that introduces a lot of uncertainty and has caused a lot of problems in matters that I've seen. And I've seen people being scared off potentially running recycling operations because of some of the tricky legal aspects there. So that would be number one, to say, if you do X, Y, Z, then it ceases being waste, and we can all we know where we stand. The second thing is the DA and Environment Protection License procedure. Getting a DA for a waste facility, modifying your DA, modifying your consent, I should say. The time and cost involved is enormous. And for all the talk about essential services, declining landfill capacity, councils, state government, EPA still sort of assess things from I need to put everything, I need to assess and be satisfied of everything now and make sure there's 50 pages of conditions and, 1,000 pages of DA documents and all the rest to be satisfied of absolutely every detail. And I understand why they take that position, but it makes it so onerous that, frankly, a lot of players just don't want to do it. And we, as a result, have a lot less critical waste infrastructure in this state and other states than we should, purely because of the approval process.
Yeah, like we've got certain targets we've got to meet by 2030, but you need the infrastructure and processing ability to do that, right? But we can't do that because nobody wants to do it because of the cost of it's just getting a circular. Yeah, I know.
Exactly. And I can't tell you how many clients come to us, for advice, during those processes. And I just, every time I think, well, this is, when we're not trying to build something here that is, this isn't like I hate to say it because I also act for a lot of developers, but like a greedy developer or what have you. This is ultimately infrastructure that is needed for the whole community. And I just think, why do so many authorities make it so difficult rather than trying to work through all these issues? They just throw it back at a lot of the people applying for approvals. And so many clients come to us now for what's called a deemed refusal, which is after 40 or 60 days that it's been lodged with the council or the state government. You can take it straight to Land Environment Court because they know they're going to be stuck in 12, 18 months of purgatory with the authority. After 6 months, they may get a letter back saying, here's 10 problems, fix them, or we'll refuse it. And then they may hear nothing for another 6 months. And so they'll go straight to court and have to spend $100,000, $200,000 on legal, on experts, on all the rest, just to speed the process, just to save 6 to 12 months on that end. It's crazy that it's come to it, but our approval process has become more and more of a ticker box sort of exercise and more of a looking for problems exercise than a collaborative sort of how can we get this done approach. And that I think, I've been doing this almost 20 years and perhaps cynically become a lot more cynical. I don't think we're going to get close to meeting those targets purely because of how difficult it is to get through the approval process.
Yeah, that's a whole new podcast. And we probably will be doing one on something similar in the near future.
Yeah.
But look, thank you very much for your time and for your insights into this into the legalese of the waste and resource recovery industry. Thank you very much.
Pleasure. Thanks for having me.
Thanks for joining us on the inaugural Inside Waste Management Review podcast. And remember, it's not waste, it's a resource that needs repurposing. See you next time.